Hi everyone, my name is Tim Zerillo and I'm shooting this video from Zerillo Law LLC in our offices at 103 Exchange Street in Portland, Maine on September 2nd, 2011. Thank you for watching this video. In this particular video, I just want to point out to you a distinction of a number of issues that I've discussed in previous videos on making sure to assert your right to remain silent. As I've told you before, silence is golden. How do you assert your right to remain silent? Well, in 2010, in a 5-4 decision in the United States Supreme Court, authored by Justice Kennedy, the case of Burgess v. Tompkins came down and really sort of, in my opinion at least, created a situation where an ordinary waiver of silence that would seem to apply doesn't apply. And I'll say what I mean by that. It's a little complicated, I know. In that particular case, there was approximately a 3-hour interrogation related to a murder of a murder suspect. The murder suspect, Tompkins, did nothing and said nothing that related to the case during those 3 hours. In effect, he just stood silent while questions were asked. Then the law enforcement officer decided to take a religious tract and started asking him questions about God, culminating in the question of, do you pray to God for shooting those boys down? To which Tompkins said yes. Now, his defense attorney quite promptly and properly said that he had waived Miranda, or that he had not waived Miranda, but that he had asserted his right to silence during the 3 hours in which he said nothing. It would make sense, right? They asked a bunch of questions, he said nothing. Eventually, you should come to the point where you would think that this means that the person who is saying nothing wants to remain silent. However, that's not what the Supreme Court said. The Supreme Court said that you need to clearly and unequivocally assert your right to remain silent. So just saying nothing under Burgess v. Tompkins is not enough when the police are asking you questions if you intend to remain silent. So what do I tell my clients? Well, sometimes what I do is, if they're really concerned, I give them the actual language on the back of one of my cards, and I can do that for you if you're concerned about a case you might be facing. But essentially the language says this: I am asserting my right to remain silent. I am asserting my right to counsel. I do not wish to answer any questions at this or any other time. Please do not answer me any questions. Please do not ask me any questions. Please contact my attorney, Timothy Zerillo, and direct all questions to him. I'd like the opportunity to make a phone call to my attorney. And that's about all it says. And I'll write that out for them on the back of one of my cards if they're concerned about the language of it. So just remember that if a law enforcement officer questions you and you want to remain silent, saying you want to remain silent is pretty important, as screwy as that sounds. But that's the United States Supreme Court's interpretation of it, so we live with it. So if you have any questions about this matter or any criminal case or any potential criminal case you think you might be facing, you of course give me a call. There are 3 other lawyers who practice criminal law at Zerillo Law who work for me, all very competent and very skilled lawyers, and of course I do as well myself. But we have a number of people in our practice who can help you out, myself included. For the office number, it's 347-6063, 347-6063 in the 207 area code. We're in Maine and we serve the entire state of Maine. I have cases all over the state, actually, from Aroostook County to Ellsworth to, of course, a lot in Portland and elsewhere. You can also go on the web to find out more about myself or about other lawyers in the firm or about the firm in general at www.getzerillo.com. That's www.getzerillo.com. Hope to be talking to you soon, and thanks for watching this video.